Honorable Judge Lehman presiding. Please be seated and come to order. Please remember to turn off all cell phones and electronic devices and refrain from entering or leaving while a witness, a judge, or attorney is speaking. Also, no flash photography. Thank you.
Good evening, ladies and gentlemen. Welcome to this final round of mock trial competition. And the first thing I would like to do is introduce our scoring attorneys tonight. We have Drew Williams. Mr. Williams is employed in private practice. He works for the Childers Law Firm. And then we also have Martin Gonzalez, who's an attorney employed by Walker and Driscoll. And we have Superior Court Judge Brooks Vanderhold. So I'd like to thank them for being our scoring attorneys tonight. I'm assuming both sides are ready to proceed, and what I would like to do at this time is ask the prosecution team to provide us with their introductions.
Yes, Your Honor. Good evening, Your Honor. My name is Brooks Hamby, and this evening I'll be presenting the pretrial motion on behalf of the people of the state of California. At this time, may our trial attorneys stand and introduce themselves?
Yes, please.
Good evening, Your Honor. My name is Lindsay Jones, and tonight I will be representing the people of the state of California in this action. Tonight I will be directing Cameron Douglas and Tony DeLuca, as well as cross-examining Adrian Vega and Taylor Berard. I will also be delivering the closing arguments on behalf of the people.
Good evening, Your Honor. My name is Sarah Stivel, and I'll be representing the people of the state of California in this action. This evening, I will be giving the opening statement, as well as directing Officer Wright, as well as Quinlan, and conducting the cross-examinations of Dallas DeCamp and Aubrey Fox.
Your Honor, at this time, may our witnesses stand and introduce themselves?
Yes, please.
Good evening, Your Honor. My name is Blair Howington, and tonight I am Officer Kelly Wright.
Good evening, Your Honor. My name is Alan Casey, and tonight I am Tony DeLuca.
Good evening, Your Honor. My name is TJ Ziegler, and tonight I am Quinn Liu.
Good evening, Your Honor. My name is Brian Wood, and tonight I am Cameron Douglas. Your Honor, at this time, may our clerk and shadow bailiff be allowed to introduce themselves?
Yes.
Good evening, Your Honor. My name is Amanda Garcia, and tonight I'll be your clerk. In this trial, I'll be giving verbal and visual time warnings, such as 2 minutes, 1 minute, 30 seconds, and time, which means the speaker must stop.
Good evening, Your Honor. My name is Cameron Abadi, and I'll be the shadow bailiff for tonight. At this time, I would like to remind everybody in the courtroom to please turn off all electronic devices and that no one is allowed to enter or exit the courtroom while witness is on the stand.
Thank you. That's an important reminder.
Your Honor, this completes our team roster. At this time, may I introduce our teacher and attorney coaches?
Yes, please.
Your Honor, our teacher coach is Ms. Sherry Newell.
Good evening, Your Honor.
And our attorney coach is Ms. Deborah O.
Good evening, Your Honor.
Thank you. Defense team.
Hello, Your Honor. My name is Stephen Edwards, EDW, ARDS, and I represent Adrian Vega in the pretrial motion.
Good evening, Your Honor. My name is Emily Stevenson, STEVENSON, and I represent Adrian Vega. I will be conducting the direct examinations of Aubrey Fox, Dallas DeCamp, and Adrian Vega. I will be cross-examining Officer Kelly Wright. I will also be presenting the opening statement.
Good evening, Your Honor. My name is Alexandra Maloof, MAL-OOF, and I represent Adrian Vega. Tonight, I will be direct examining Taylor Berard. I will be cross-examining Quinn Liu and Cameron Douglas. I will also be delivering the closing argument.
Good evening, Your Honor. My name is Adriana Rojas, R-O-J-A-S, and I am Aubrey Fox.
Hello, Your Honor. My name is Tatiana Sinez, S-E-A-N-E-Z, and I am Taylor Berard.
Good evening, Your Honor. My name is Clarissa Evangelist, E-V-A-N-G-E-L-I-S-T, and I will be Dallas DeCamp.
Good evening, Your Honor. My name is Brittany Studer, S-T-U-D-E-R, and I am Adrian Vega.
Good evening, Your Honor. My name is Do Kim, K-I-M, and I will be your shadow clerk tonight.
Good evening, Your Honor. My name is Kelsey Hughes, H-U-G-H-E-S, and I will be serving you this evening as your courtroom bailiff.
At this time, Your Honor, we would like to introduce attorney coaches, Mr. Marco Nunez and Jill Christie.
Good evening, Your Honor.
All right, thank you very much. You can be seated. At this time, I'll ask whether both sides are prepared to read further reading of the rules and also the stipulations. Are you prepared to waive that?
Yes, Your Honor, the defense waives.
The prosecution also waives, Your Honor.
All right, thank you. First matter of business for the court is to decide a pretrial motion brought by the defense to suppress the defendant's confession or statements. And Mr. Edwards, you're prepared to present that argument?
Yes, Your Honor.
All right, please proceed.
Your Honor, the defense moves to suppress statements made by Adrienne Vega on grounds that these statements were taken in violation of her Fifth Amendment rights against self-incrimination. Suspecting Adrienne Vega of being involved in a hit and run, 2 police officers arrived at Adrienne Vega's house late at night, where they soon engaged Adrienne Vega in conversation before moving her to the back of a caged police unit, where the questioning continued. During the questioning, Your Honor, the door of the unit was locked, and Adrienne Vega was never told that she was free to terminate the interrogation or leave.
Well, let me ask you this, Mr. Edwards. The facts are clear that the defendant at no point was told that she was under arrest until after making the statement, right?
Well, yes, Your Honor. However, the fact that Adrienne Vega was never under arrest until after she made this statement does not necessarily indicate that she was not in custody.
But you would agree that that's one of the factors for the court to consider?
Well, yes, Your Honor. It is one of many factors for the court to consider.
And also, the defendant was not handcuffed. That's usually associated with a person being placed under arrest. They're told they're under arrest, they're also handcuffed, but that didn't happen either, did it?
Well, no, Your Honor. However, again, the fact that Adrienne Vega was not placed under arrest or handcuffed is not necessarily indicative of her not being under arrest. We must consider the totality of the circumstances in this case and balance several factors in order to determine whether or not Adrienne Vega was in custody. These factors you mentioned, Your Honor, are certainly go toward the totality of the circumstances. However, overall, Your Honor, the circumstances in this case point to Adrienne Vega being in custody.
Proceed.
During the interrogation, Adrienne Vega made statements which could be construed as potentially incriminating. The question in this pretrial motion, Your Honor, is whether or not the police officer in this case had a legal obligation to give Adrienne Vega the Miranda warnings prior to custodial interrogation. The answer to that question, Your Honor, is yes. In Miranda v. Arizona, the United States Supreme Court determined that it is the legal responsibility of police officers to warn suspects in custody of their rights prior to a custodial interrogation. In Berkmer v. McCarthy, the United States Supreme Court defined what it means to be in custody. In order to be in custody, Your Honor, a person's freedom must be significantly restrained. Based on the holding in Thompson v. Keohane, we know that the standard is objective. In that case, the court held there are 2 essential inquiries needed to determine whether or not an interrogation is custodial. First, what were the circumstances surrounding the interrogation? And second, given those circumstances, would a reasonable person have felt he or she was not free to terminate the interrogation and leave?
Well, counsel, is it your argument that the defendant was placed in custody, in effect, when the officer put him into the locked patrol car?
Well, Your Honor, there were essentially 3 stages of the process of getting Adrienne Vega into the car. The first was outside of the patrol car. The second, Adrienne was sitting partially within the car. And the third, Adrienne Vega was sitting entirely in the car with the door locked. It is at this point, Your Honor, that Adrienne Vega was in custody.
Right, so we're really concerned about what were the circumstances at the time he made the statement, and he was in the back of the patrol car, locked inside, right?
Yes, Your Honor.
Okay, but he didn't know he was locked inside, did he?
Well, no, Your Honor. However, the fact that Adrienne Vega did not know that she was locked inside the police car is not necessarily indicative that she was not in custody at the time.
Well, certainly your argument would be stronger if the officer told or directed the defendant to sit inside the patrol car, but the defendant said that she was cold, and the officer said, in effect, it's warm in the patrol car, right?
Well, Your Honor, the circumstances surrounding that statement that Adrian Vega complained of the cold and was shivering were that Adrian Vega complained of the cold first, and then Officer Wright pointed to the police unit. Once Officer Wright had pointed to the police unit, Adrian Vega sat halfway inside and halfway outside of the unit, with her feet firmly planted on the ground. However, after several more minutes of talking, Officer Wright then closed the door on Adrian Vega. So while Adrian Vega may have initially complained of the cold, at the point at which the officer put her in custody, Adrian Vega was no longer complaining of the cold weather.
Thank you. Proceed.
In accordance with People v. Herndon, the court must look to the totality of the circumstances and balance several factors. Was the individual free to leave? What were the surrounding circumstances of the interrogation? Was the purpose of the interrogation to question the person as a suspect or a witness? And the length and form of the questioning. When we apply the facts of this case to the rules, Your Honor, it's evident that Adrian Vega was in custody during police questioning. Turning to those factors. Was Adrian Vega treated as a suspect by the police? Yes, Your Honor. Adrian Vega was considered a suspect by Officers Wright and Jackson prior to any questioning of Adrian Vega. Now, Your Honor, was this a lengthy interrogation? Yes. Adrian Vega was questioned in the back of the police unit for a full half hour. Now, Your Honor, were the police officers in this case fully uniformed and armed? Yes, Your Honor. Both Officers Wright and Jackson arrived at Adrian Vega's house fully uniformed and equipped as law enforcement officials. Were there multiple police officers present at the scene? Yes, Your Honor. There were 2 police officers present, Officer Wright and Officer Jackson. While Officer Wright interrogated Adrian Vega inside the police unit, Officer Jackson stood a few feet away from the unit, staring at Adrian Vega throughout the course of the interrogation.
1 minute.
Now, Your Honor, was Adrian Vega isolated from others at the time of the interrogation? Yes, Adrian Vega was placed alone in the back of a caged police unit where the interrogation took place, with only Officer Wright and Officer Jackson present. Now, Your Honor, at any point in this process, did Officer Wright or Officer Jackson tell Adrian Vega that she was ever free to leave or terminate the interrogation if she wished? No, Your Honor. Officers Wright and Jackson neglected to tell Adrian Vega that she was free to leave or terminate the interrogation. Under the totality of the circumstances, Adrian Vega's freedom was significantly restrained. A waiver of her rights was required and never solicited, and therefore Adrian Vega's statement should be suppressed from trial. Thank you, Your Honor.
Thank you, Mr. Edwards. Mr. Hanley, the people have a response?
Yes, Your Honor. Now, Your Honor, opposing counsel just stated that the police officers in this case, Officer Wright and Officer Jackson, neglected their duties as police officers to give the warnings to the defendant in this case that she was free to leave. However, Your Honor, that is not legally required in what we have to apply here. Your Honor, the defendant was not in custody when she was talking to Officer Wright, and the totality of the circumstances would not lead a reasonable person to believe that their freedom had been restricted.
Counsel, the cases make some reference to a police-dominated atmosphere. You're familiar with that phrase, right?
Yes, Your Honor.
Okay. Wasn't this a police-dominated atmosphere? The officers made it clear from the very beginning of the contact that the defendant was a suspect. There were 2 officers who were present giving the defendant directions, and as counsel has argued, this took place over a period of time. Wasn't this the kind of police-dominated atmosphere that the cases are concerned about?
Well, Your Honor, Craighead versus the United States discussed one of these issues as being the number of police officers. However, Your Honor, what we have to look at here is not just the number of police officers, but what were the alternatives that we had. And the police officers in this case could have had a viable alternative. They could have gone to the police station in this case. However, Your Honor, when we look at these 2 alternatives, one being the police car in front of the defendant's house in the defendant's well-known and relatively comfortable neighborhood,